So at this time, I'm going to share my screen. Just a little presentation I made. Can everyone show? This presentation is basically just to discuss the gun laws that affect North Carolinians currently, as it lays out, the federal and state law. So to start, obviously, is the Second Amendment of the United States Constitution, which is a well-regulated militia being necessary to the free state, or being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. So one thing about the Second Amendment is that the United States Supreme Court does not really want to touch the Second Amendment because it's such a politically divisive amendment between, the Republicans and the Democrats. So they haven't really laid down a ton of case law. I think the first case that really addressed the scope of the Second Amendment was the District of Columbia v. Heller, which was in 2008. The Supreme Court of the United States announced that there is an individual right to possess a gun in connection without, being part of a militia. So it read that, the well-regulated militia part does not affect the ability of an individual to own a gun. So that was a federal standpoint. And then the Supreme Court always incorporates this through the 14th Amendment, which basically means that the state is now bound by the same rules. And they did that in McDonald v. City of Chicago, Illinois in 2010. So North Carolina also has a similar constitutional section in it that addresses your right to own a weapon. I'm not going to read the whole thing. If you would like to read it, it's there in quotes. But the extent of this is basically that the North Carolina Supreme Court has held that you have broader individual rights to own a gun than under the United States Second Amendment. So that means basically that the protections are greater and there's less regulations can be imposed on those in North Carolina under the North Carolina Constitution as opposed to the United States Constitution. But at the same time, they've also said, there's reasonable regulations to preserve the peace and safety of the public. So a lot of that has been expressed through court cases over the years, and really it's narrowed down to North Carolina can regulate the time, place, and manner in which a gun is possessed. So, government buildings, schools, you have to, store it in certain ways. So there's all those different manners that we'll touch on in a little bit. So acquiring a weapon in North Carolina. So right now, if you are 18 years old or older, you can purchase what is called a long arm gun. That is your typical rifle or shotgun. And also to buy a handgun, you have to be 21. The difference is that the handguns are what are used most to cause, most of the crimes. Most handguns are used as opposed to a rifle or shotgun. So the age difference is there based on, 18, 19, 20-year-olds being one of the larger populations of people that commit violent crimes. And so that's the difference between the 18 and 21-year-old age group between the rifles and the handguns. And this is also interesting. So under federal law, you can actually just loan someone your gun for a temporary purpose if they're going to go sporting. So if they're going to go hunting or go shooting targets or anything like that. However, North Carolina has never really addressed this issue. This is just under federal law. So maybe, in the future, North Carolina will address this issue. So back to the acquisition of a long arm gun. So, your rifle and shotgun, your typical hunting rifle. So you can buy these through private sales. You can also buy them through a gun store. So through private sales, you have no obligation to do a background check or maintain records. The only requirement under the law is that a person knows or reasonably knows that this person is not restricted from buying guns for reasons such as, being a convicted felon or restricted because of past mental illness or past, substance abuse. And that's 18 years of older. But at the gun store, however, you have to fill out a form 4473, which is basically just your name, address, some fingerprints, your a background check. You have to meet some requirements for that form. And then you have to pass an NICS background check. Was the same you would go through for, a job, just checking your criminal history and anything else that they deem important there. And that's also 18 years of age as well. So now the acquisition of handguns and pistols is different, like I spoke earlier. You can buy these through both private and gun store sales. So this is where it's a little bit different than owning a long arm. You have to have a pistol purchase permit. It's a mouthful. To buy from both private and a licensed gun store. So each pistol or handgun that is purchased, there must be a pistol purchase permit attached to that handgun. So it kind of keep track of the pistols in a greater manner. So you can get these through your local sheriff's office. They're required by law to keep them on record. So in Winston-Salem, Sheriff Kimbrough, his office would have the opportunity to see, to hand you a pistol purchase permit. And these include, fees, background check. You have to go through a mental health screening, and one permit per handgun. And then there's also specific laws, which we'll get into later, that prevent people from having guns. So here are the prohibitions currently under federal and state law. I won't go through all of them. I will just highlight a few that they can be restored at a later date. So if you're a convicted state felon, you can eventually have those restored by court through an order. Also, if you've been deemed to have, substance abuse issues in the past, you can also have a court restored. And also if you were deemed mentally ill. So all three of those ways under state law, you can have those redeemed. However, under federal law, if you are a convicted felon, you are banned permanently for life from owning a firearm under federal law. And so there's a couple more. I'll give you a second to read them. So undocumented immigrants may not have a firearm, dishonorable discharge. So there's a couple there that certain groups of people are not able to own or possess a firearm. So then there's also a list of firearms that have been restricted in the National Firearms Act of 1934. So these are rifles that have shorter barrels and shotguns so basically guns that have shorter barrels have been, more restricted than other guns because of their potential of, causing harm and leading to being used in crimes and being concealed easier, things like that. So there's, suppressor silencers as well, because, if you can't hear it, then, no one will be able to, react and address the crime and, try to find some justice with the person that committed the crime. So basically, with these restrictions, you have to go through another background check, a waiting period, and a $200 tax stamp. So, if we were to try to make some more changes, trying to look at these regulations that are on these certain firearms, maybe extending them to all firearms could be a great step in the right direction. So, right now, you don't have a waiting period the same way that you have for other areas of your life.
You got some headphones?
So maybe try to implement some of that and, a more extensive background check, especially, we know about some of the loopholes, especially with the private sales, not requiring background checks. So extending this type of regulation to all guns could be a great way to go about that. Also machine guns, which is insane to me that you can buy a fully automatic machine gun. North Carolina does not, prevent any ownership of any of these types of firearms. They just have to meet the requirements under the federal law of the National Firearms Act of 1934. And so now assault weapons. So that's a hot topic always in gun legislation, and especially, in policy standpoints. Currently in North Carolina, there's no restrictions on assault weapons. There was a federal ban that was previously implemented for 10 years between 1994 and 2004. A lot of these restrictions have been focused on the look of the gun as opposed to the specs of the gun. So some of the typical ones that have been laid out for these assault weapons is usually a semi-automatic weapon, so like an AR-15 or AK-47 that kind of look, your typical look of an assault weapon, but there's also these different features as opposed to the actual specs of the gun, and I'll explain shortly. So like, for example, here's a couple pictures of weapons. So obviously the one on the right looks very scary, and so does the one on the top left. They look like they'd be, more dangerous than the one on the bottom left. However, they have the same ammunition, same velocity, same rate of fire, and same capacity. So one thing, instead of focusing on the look of the gun, focusing on those types of different aspects of the gun could be one way that we limit this gun violence in our community, and the ability to cause massive casualty. I know recently the bump stock was banned, so that was a way that like made it the rate of fire go faster. So different regulations can be brought forward to address those as opposed to the actual look of the gun. And so now concealed carry in North Carolina. So we have concealed carry in North Carolina. All you have to do is apply for a permit, and they're available in the sheriff's office, just like the pistol purchase permit. And they're also in a few other areas around the area. The requirements right there are listed in North Carolina General Statute Section 415.12. So it's an application, a fee, fingerprints, and then you have to go through a course, and then a mental health disclosure, anything you've had in the past in terms of, mental health or mental illness has to be disclosed to the sheriff of the area where you get the concealed carry permit. And so these are the areas in North Carolina that you can carry a firearm, concealed carry a firearm. Just take a look at a few of those. One of that struck me that's interesting is, you can have one on educational property as long as it's locked in a vehicle. A public school, you're allowed to have that right, which seems strange to me, especially with, the rise of, gun violence in schools, and how prevalent it is in our society. Private schools, because they're private lands, they can restrict this right as much as they would like to. So those are a few of the areas. Typically, can't carry. Besides the locked and the gun safe at schools, it's usually schools and government property are kind of the go-tos for where you cannot carry in North Carolina. And so open carry, so that means just carrying it, on your back, or carrying it in your hand, or, carrying it to your side, just where people can see it. There's no North Carolina statutes that limit open carry. So the only violation of North Carolina law is if you are, brandishing a weapon to, terrorize the public. So, if you're doing it to incite fear in people's, eyes, then that could be, the violation of law. However, just carrying it is not a violation of law. There are cities that do implement some ordinances that restrict the ability to open carry. So that's one positive step in the right direction to, limit the ability to open carry, because, it could be argued that anytime an open carry exists, it could put many people in terror and fear in general. So this is one example. Winston-Salem has a city ordinance where you cannot carry openly in a motor vehicle, a parking area, or a building. It does limit the ability by Winston-Salem city ordinance to carry a weapon openly, or carry a firearm openly. So there's very few places that you could still open carry in Winston-Salem. And so North Carolina self-defense, I thought, it'd be useful to just address this area, especially, as it pertains to certain cases, especially the Trayvon Martin case, and how that implemented, especially in Florida, how maybe North Carolina looks at it. So I would just read it because I think the language is very useful to know. Under North Carolina General Statute 1451.2 and 51.3, a person can use deadly force if you reasonably believe that such force is necessary to prevent imminent death or great bodily harm to self or another, or you are in your home, vehicle, or workplace, and that the person against whom the defensive force was used was an unlawful intruder or was attempting to forcibly and unlawfully enter one of the above. So that's also called the Castle Doctrine, and that's been in play for hundreds of years. I mean, it's a common law doctrine that goes back to the English common law. So that's been around for a while. And then also, you're not justified in using deadly force if a person is attempting, committing, or escaping a felony. So just because someone is stealing something from your home, if you do not have reasonable belief that that person is going to cause great bodily harm or injure you, you are not justified in using deadly force towards that person. So shooting them, for example. And also, if you are the first person, if you approach someone and start a fight, you are not then allowed to say, I was in self-defense later if you end up shooting your gun at someone. If you're the first person to initiate that violent interaction, you cannot use the firearm. And so here's just a list of firearm-specific crimes, and I'll make sure that we get this out to everyone that's in attendance tonight and more. I'll make this readily available. I just compiled this list of different gun laws that affect North Carolinians, and these are just firearm-specific crimes. There's a couple slides here. Class D is the most serious, all going down to Class D, E, F. So armed robbery is likely. I mean, obviously, murder with a weapon is a higher felony than that. But these are just firearm-specific offenses. So armed robbery, because it's a firearm with robbery, it extends to the Class D felony. So everything is usually elevated with the firearm. So there's just a list of those. I'll make sure you get them at a later date, and then it goes down even more. One that's really interesting is for a long time there was no ban in North Carolina on having a ban on owning a firearm under a domestic violence protective order. So let's say you go to court and someone brings you to court and says, I want a domestic violence protective order because this person's harming me in my home. The court adjudicates it and decides that yes, you are a threat, and orders this domestic violence protective order. For a long time, there was nothing preventing that person from owning a firearm. So that's a relatively new change, and a change in the right direction because, knowing now that, if there's a history of domestic violence, now there's a much greater chance that there will be violence in the future. And so preventing the individuals that are under those orders from owning and possessing a firearm has been a good change in the right direction. And then there's some misdemeanors as well that you can take a look at. And then thank you so much for your time.